The Western Cape High Court has ordered the immediate release of a mother who was sentenced to 16 years behind bars for alleged drug dealing. Minkana Elizabeth Makgoba was sentenced in July last year, but the magistrate at the Beaufort West Magistrate Court is said to have committed a litany of errors. What happens in such cases? Legal expert, Advocate Zola Majavu joins us now for his opinions. Good afternoon, Mr. Majavu. Thank you very much for joining us. I mean, what a case, eh? I mean, what kind of errors are these that the High Court has found that the Beaufort West Magistrate committed in sending someone to jail for 16 years and now ordering her immediate release?
Good afternoon, Braden. Good afternoon to your wonderful viewers. Firstly, the High Court found that the magistrate presiding in this matter was over hasty, firstly, in making a decision for the child to be removed from the care of the mother, even ahead of the sentencing, processes. This would be a case where the mother had, for whatever reasons, indicated that she wanted to plead guilty. The second phase of the hearing would have had to be the one that deals with the sentencing. And it seems to be there where the magistrate got it very wrong. She also did not allow, for mitigation purposes, a request to have the pre-sentence reports. Ordinarily, once a person has been found guilty, either voluntarily by a plea of guilt or by the court having listened to all the evidence, prior to sentence being passed, that particular person has a right to lead evidence of whatever nature.
But now, in such cases, I mean, she's already been in jail and for a short while, but the court is very clear she must get immediate release. Does she have any recourse at all?
He would have a recourse because, remember, the Court of Appeal is bound by the record of the proceedings below. So I was trying to explain to you what it is on your instruction, the request that the court had found was material irregularities. So in this instance, the court has duties were of such a nature that they resulted in a travesty of justice and she must be released immediately. What is open to her, she may sue the state for those years that she spent in custody in instances where she ought not to have been subjected to that term. But I would not think that she'll get very far because in this instance, she on her own accord have pleaded guilty and the court did not disturb the guilty finding.
Okay, so now she's going to be released and the children, I mean, she should have the child back or the children back.
Indeed, she should, unless the social workers, having investigated what the material conditions that would be suitable for the children, recommend otherwise. But obviously, she is the biological mother. She's the primary caregiver. However, if it is determined that it is not in the best interest of those children to be released to her custody, then it is open to a court to make that determination on advice of proper reports by the social workers and other experts who are independent enough. Because remember, the court is the upper guardian of all minor children.
So is that the family court?
No, the courts generally, the High Court is by law known to be the upper guardian. So if, for example, the social workers are of the view, having conducted various investigations, that it is not in the best interest for that child to be reunited with their mother, they can make that recommendation and it is open to the court to accept or reject that recommendation. But it's usually not a decision that is taken lightly.
And what about the magistrate? As we conclude, Mr. Majavu, the line is not great. Finally, I mean, what action can be taken against a magistrate who commits such a litany of errors according to the High Court?
Well, unfortunately, there isn't any. There are judicial officers who are insulated by virtue of the office they occupy. Our legal system is such that such errors are capable of being corrected on appeal. And this is exactly what happened in this instance. It is unfortunate, but that is just how it is. You may not take legal action against a judicial officer who happens to get it wrong, no matter how frequent the wrongdoing on their part might be. At best, it may point towards incompetence. And if incompetence is of such a nature that it warrants some form of censure, there are judicial processes that have to be undertaken. But this is not one such matter. She clearly got it wrong, and the High Court had corrected it. And unfortunately, 16 years later, or a couple of years later.
Okay, thank you very much. Zola Majavu, legal expert there, just weighing in on this case. But at least the mother now, he's going to be released immediately and hopefully be reunited with the children. Still ahead on today.